Hi, I'm Michael Pepe, a policyholder, lawyer, and partner at Sachs, Dornberger & Vita. Thank you for registering to watch the fourth installment of our webinar series, COVID-19, the Impact on Insurance Coverage and Claims. SDV is a national insurance coverage law firm. We represent policyholders in disputes with insurance carriers, and we advise and counsel policyholders and their brokers on insurance coverage issues. The COVID-19 pandemic is an unexpected event that's brought insurance coverage issues into the spotlight. With many businesses scratching their heads looking at their insurance policies to understand why insurance carriers are saying that their policies don't cover the coronavirus. As you've seen in our prior episodes of this webinar and other articles on our website, the issues aren't quite that simple. And for certain policyholders, there are paths to finding coverage. Today, we're going to focus on first-party property policies. My practice includes representing real estate developers, REITs, global investment funds, and other property owners who are incurring losses of business income and additional costs associated with owning and developing their properties during this shutdown. Tracy Sachs and his panel tackled the main elements of business interruption coverage a few weeks ago in the first installment. Today, I want to focus on the potential for coverage under protection of property or sue and labor provisions in first-party property policies. We addressed this in an article on our COVID-19 resource page, which you can find on the SDV website. It was written by my partner Jeremiah Welch and Will Bennett. Today we'll explore this issue in a little more detail. First, let's quickly recap the challenges to finding coverage under a first-party property policy. Most policies have some trigger language that requires physical damage or loss to tangible property in order to access the coverage. There's a big dispute right now as to whether the presence of coronavirus or people infected with the coronavirus on an insured's property constitutes physical damage or loss. And that's an issue that's going to be in almost any case. Once you establish that there is physical damage or loss to property, then you have to deal with exclusions like the virus exclusion, potentially pollution exclusions, and other exclusions that may come into play. Again, my partner Tracy Sachs addressed that in a lot of detail in the first installment of this series, so go back and check that out. But one aspect of many first-party property policies that's been largely overlooked when we talk about coronavirus and the associated shutdowns is a protection of property provision. This provision is found not in the insuring agreement, and it's not found in the exclusions of the policy. It's actually found in the policy conditions, and sometimes it's called protection of property. Sometimes it's referred to as a sue and labor provision. And these are provisions that actually require, as a condition of the coverage under the policy, that the policyholder do certain things in order to be in compliance with the policy. And one of those things is to make sure they actually protect the property that's being insured, to mitigate potential losses, to take actions when something is going to happen. There's something imminent, like a hurricane coming would be a good example, or when a loss begins, to then take steps to prevent that loss from getting worse, to protect property from further loss, and to make sure that they don't just allow the property to become damaged or more damaged than it otherwise would be because the insurance is going to cover the potential damage. So these are found in the conditions section of the policy, and most first-party property policies have some form of this provision. So let's talk about what they said. So a sue and labor clause originating in ocean and inland marine insurance policies, and it requires the insurer to protect damaged property from further loss once a loss has occurred. It also establishes that the expense of doing so will be borne by the insurer and the insured in proportion to their respective interests under the policy. So taking into account things like deductibles or self-insured retentions and limits, of course. But what it means is that the insurer will pay the full sue and labor cost, protection costs, if the amount of insurance is equal or greater to the value of the property. In current property and marine forms usually contain a provision like this, but it's usually not called a sue and labor clause. It's, like I said, it's usually called a protection of property clause, and it can be found in the duties in the event of loss section of the policy. So a good example of this would be placing a tarp over a damaged roof to mitigate further damage. cost of that tarp and getting it up there would be covered as a sue and labor cost. One thing to keep in mind is that a sue and labor provision, because it's not part of the insuring agreement, it's part of the conditions and the duties of the policyholder, doesn't require a loss occurrence to have actually taken place like other losses covered under the policy. Instead, the policy actually places this as an affirmative duty on the insurer to take these actions in order to protect the interest of the insurer. So be aware of sublimits and deductibles when you're looking for these provisions in your policy. Traditionally, deductibles wouldn't apply because, again, the deductible applies to a loss occurrence. And when we're talking about sue and labor costs, we don't have a loss occurrence necessarily yet. The loss occurrence is something that's going to happen in the future or continue to happen in the future. So traditionally, in this case, a lot of support the idea that the deductible wouldn't apply. But a lot of modern policies have actually written deductible and even sublimit clauses into the protection of property section of the policy. So look at your specific policy and determine whether you have to deal with those with sublimits and deductibles to figure out whether it makes sense to make this type of claim. Okay, so protecting your property in the era of COVID-19. There's two things we're going to talk about: protecting your property from COVID-19, from the virus and from its spreading, and also protecting the property from other causes of loss. So let's first take protecting the property from COVID-19. When we think about COVID-19 and the related losses that we might be dealing with, the question becomes whether any of those losses incurred were incurred for the purpose of protecting from further loss once the loss happened. So if I know that I have a tenant or a customer or an employee who was on my property who was infected with the virus, I know that I'm going to have to take additional measures, whether they're required by a state or local ordinance or just good business practice, to do some disinfecting, to take more precautions with how I route people through my building, how deliveries are made, or how service that is still going on during the shutdown can actually be handled in order to prevent or attempt to prevent the spread of that virus. Assuming we get past the argument that the virus causes physical damage, and again, leaving that aside for purposes of today, there would be additional damage if that one person or a few people who were infected and came on your property continued to infect the property. The pandemic would spread through your building, through your employees, clients, customers, tenants, and actions that you take to prevent that further spread, that further physical damage of the coronavirus throughout your property, or even from one property to the next, if you have a policy that insures multiple properties, would be preventing a future loss. And there's an argument that those costs should be covered, not as a new covered loss themselves necessarily, but as protection of property from future losses or from losses that might occur. So that's how we think about coronavirus. And again, as I mentioned, we still have all the problems that we would normally have, all the issues we've been talking about with getting into the policy in the first place. Does the coronavirus or COVID-19 cause physical damage to property when it's present on the property or within the property? This doesn't alleviate that concern, but it does create an avenue for coverage of those costs to prevent the future damage. So what about other types of losses? Here's where I think this issue gets a little interesting. When we think about other types of losses, not just the spread of the disease or additional costs that I have to do in order to clean up the disease or comply with government orders. What about things that I just have to do in the normal course of my business because the business is shut down in order to prevent losses that I wouldn't have had to think about if my business was running as usual? So a really good example here is with construction projects. If I own a property and it was in the middle of construction at the time of coronavirus and it was ordered to be shut down, and we decided to shut it down during the coronavirus pandemic, I can't, depending on the project, but it's not likely that I can actually stop all activity. and just leave the site abandoned. Doing so probably isn't a good idea for a number of reasons. So what are the things that I have to spend money on during the shutdown that I wouldn't have had to spend money on otherwise? Think about those things and think about whether those might be covered under a protection of property or sue and labor provision. So for a couple examples that we've been kicking around, security is a good one. I would normally have to pay for site security, of course, but if I had a 12-month project that, depending on how long the shutdown lasts, goes 15 months or 18 months or even longer, and I have a period of time where I wasn't doing any construction, I still have the amount of security that I would have had for my 12-month construction period that's spread out, whatever I had spent before the shutdown, and then that portion that it takes to finish the project once I go back, I'm still going to spend that amount. So now I have this extra amount of security. During the shutdown, I have to keep people on site to make sure that my site isn't looted. Who knows what can happen when you have an abandoned construction site, to make sure it's locked. There's fire protection. There's security to prevent vandalism of pipes and wires and other valuable things that are on a construction site. Those are additional costs. They're costs I wouldn't have had in the absence of coronavirus. But if we go back to the analysis about physical damage and virus exclusions, the loss that they're preventing is not the actual presence of the virus on the property. It's a virus exclusion isn't going to apply to that loss. Physical damage, I'm actually preventing physical damage. I'm preventing someone from coming onto the site and stealing the copper. That would be a covered cause of loss. If it weren't during the coronavirus, it still should be a covered cause of loss during the coronavirus. And I'm specifically expending costs that I wouldn't have otherwise incurred to prevent those types of losses. So that's one example. And that's something that may be taking place not just on construction projects and builder's risk policies, but for commercial and residential tenants as well, probably more commercial. If you have tenants whose businesses are shut down and they're not open to their hours. Is anyone taking on additional security functions and costs there? Another thing to think about with construction costs is actual construction costs that go over and above to protect certain types of damage that could happen to a construction project that was stopped right in the middle of the project. If you're in the middle of a digging operation, you have open wells and open excavation, and there's shoring there. Leaving it unattended for a long amount of time could lead to subsidence. It could lead to walls caving in. Obviously, the specifics would vary based on the project, but you can imagine the types of things that you have to spend money to monitor even during a project that's shut down, to make sure that when you're allowed to work again, you can pick right back up and not have to clean up any damage. So things like water monitoring, monitoring level and subsidence issues, and any other maintenance type tasks that have to happen. You have to go onto the site and start up and oil the machinery and the cranes. Those are costs that you wouldn't have had if the project just went as normal. So I think protection of property and sue and labor clauses might be one way to think about adding up those costs. Obviously this isn't the big business interruption damage that we're talking about. It's probably not the biggest portion of the loss that policyholders are facing out there, but it is a portion of it. And it is something where you can make an argument that potentially gets you around the big issues that we've been dealing with around coronavirus, the physical damage to property and virus exclusions, pollution exclusions. The issue that I see most likely, and again, depending upon language of the specific policies and the specific facts, is some of these provisions require that the loss that you're preventing be imminent. So to the extent that there are claims made around this, I see that being the central issue, is proving that the type of thing that you're preventing being something that's imminent, and that could vary based on the specific facts that you're dealing with. You know, is a theft imminent? If I don't have security in an open construction job site, there might be a number of factors that weigh in favor of imminency or that it's not. And there might be local case law that discusses what means imminent in various contexts, and maybe in specific in the construction context we've seen in a couple of states. But I think the important thing here is it's an avenue potentially for recovery, and it's something that policyholders as well as their counsel and brokers should be thinking creatively about in how some of these additional costs might be covered in the time of coronavirus. So what are the takeaways here? First, you want to look at all of the policies that may apply: your commercial property, your builder's risk, any other first-party coverages that you have, whether it's specific to a property, that cover a portfolio of properties, and see whether you have a provision for duties in the event of loss. See whether there's a specific protection of property provision or a classic sue and labor clause. And even if not, sue and labor is a common law doctrine that may apply. Then you're going to want to identify, track your costs and your losses over time and see what types of costs you're incurring that might fit into one of these provisions and might be the basis for a claim. Think about all the things that we talked about being spent to prevent the virus from showing up on your property, the virus from spreading through your property, but also the things that are preventing other types of physical damage, actual damage to an open construction site, for example, damage to buildings and units that aren't being occupied and used and cleaned every day, and what types of costs that you're incurring to prevent physical damage to your properties during that time. Things that you're thinking about to actually prevent that damage that would be covered. So think about those costs. Consider whether the damages that you're preventing, by incurring those costs, whether those are imminent and what imminent might mean. And then, of course, pay attention to the sublimits and deductibles. In some cases, you may have some costs, but there's a high deductible or a high SR in your policy. It doesn't make sense to make the claim. We always want to be practical when we're thinking about claims. So think about those things and talk to your broker, talk to your claims people, your counsel, and figure out whether it makes sense. So again, protection of property provisions may offer some access to coverage during the coronavirus pandemic. Every situation is going to be unique. Policies have different language. We have specific facts. We have specific dollar amounts and deductibles and sublimits that may apply. But it's absolutely something that policyholders who are thinking critically about coverage and want to be aggressive with their coverage should be thinking about. Thank you for watching. If you missed episodes 1 through 3 of the series, you can still access them by signing up for our website and registering. Stay tuned next week. My partner, Bethany Barisi, will be talking about bad faith issues as, again, dealing with coronavirus claims. You can find out a lot more about COVID-19 insurance issues, including a national tracker of pending insurance coverage cases within the U.S. on our website, so be sure to check that out. If you have any specific questions about this topic, any other insurance coverage topic, or even if you have ideas for future webinars, feel free to email me, contact me on LinkedIn, or contact any of the other 40 policyholder coverage attorneys that we have at SDV. Thank you again for watching. Stay safe and be sure to support those who are supporting us through these difficult times. Thank you.